Welcome once again to Lehto's Law. Here's Steve Lehto.
Sean sent me a note, so Steve, check out this story from the Associated Press out of Missouri. And this is the kind of story that will really make you stop and think. Now, it looks like it's going to end okay, but you can imagine if you were in this situation, you'd still be nervous. Missouri execution plans move forward despite prosecutor trying to overturn murder conviction. So here, the prosecutor has come to court and said, I can prove this man on death row is innocent. And the court has said, well, then you better do that fast because he's scheduled to be executed. Can you put a stay on the execution until we can have this hearing? No. And there's a reason for it, but again, the Missouri Supreme Court last week ruled that the execution plans for Marcellus Williams will move forward even while prosecutors are working to overturn his 1998 murder conviction. And again, 1998 is the date of the conviction. And here we are a few years later. So the mills of the gods grind slow. Judges on Friday decided against halting the execution, despite the fact that there's a St. Louis County Court hearing set for August 21st. Now, that hearing is before the execution. Other way would not make sense. The man was convicted of first-degree murder back in regarding a murder that took place in 1998 that took place during a robbery in the victim's home in St. Louis. Now, the St. Louis County prosecuting attorney has filed a motion to vacate that conviction, citing new DNA evidence and saying that he believes that the defendant was not involved. Simply wasn't involved. And here's the thing. You have to understand that DNA has come a long way since you first heard about it. And it used to be that they had to have a really, really good sample and all kinds of stuff. And it's gotten to the point now where they can work with really, really small samples and still get definitive results, even after a long period of time. So if somebody saved the evidence from 1998 and they tested it now and there was something going on where they could say, okay, and I've had people say, Steve, just because a piece of DNA came back for somebody else doesn't prove somebody's innocent or guilty or whatever, because who knows where it came from. It depends on the circumstances and where they got it from. And so in this particular story, it does not say where they got it from. But you've heard me talk before about Timothy Masters. And I wrote a book with him called Drawn to Injustice about how he spent 10 years in prison for a murder he did not commit. And the prosecution had come up with this theory about how he had done it. And now the victim had her clothes moved, presumably after she was dead, by somebody else. And so DNA experts in later years said, if we examine that clothing, we can tell you who pulled on her clothing because of touch DNA. And of course, the prosecutors fought that. They didn't want it tested for some weird reason. But a judge said, that'd be interesting. I'd like to see what happens. And they came back with someone else's DNA. And it was a person that she knew. And that was the only DNA they found that made any sense. I say that because once in a while, DNA samples get contaminated, for instance, by police officers themselves. So if they find somebody and they've got clothing that they know is touched by the perpetrator, and they find a hit for someone she knows, and a hit for one of the detectives working on the case, chances are the detective working on the case simply contaminated the crime scene, but not in a way that would rule out the other DNA results, okay? And so, depending on the circumstances, and so the prosecutor's saying, I can prove this with the evidence we have. Just need to get in front of the judge on this one. So there is a 2021 Missouri law that allows prosecuting attorneys to file a motion to vacate a conviction if they believe the inmate could be innocent or is otherwise erroneously convicted. The filing prompts a hearing before a judge. Keep in mind that the traditional process is you get put on trial for a crime. If you get convicted, you can appeal that crime, and you can work your way up the ladder till you hit the state Supreme Court. If you lose there, you can start over in the federal court system on a habeas corpus theory, that is, you've been locked up in violation of your constitutional rights, but then you've got to make arguments about how what happened to you was so profoundly unfair it violated your rights. And so it's harder to get out there, but of course you're simply exhausting all of your remedies. So I suspect that this guy has exhausted all of his remedies. Keep in mind that usually when you hear about somebody who's trying to get out of prison saying, I'm innocent, I'm the wrong guy, it's usually him and a defense attorney who are making these arguments. Here it's the prosecutor. The prosecutor is saying that we believe this man is innocent. We want him out. And so this is not even an adversarial setting, meaning that it looks like there's not going to be anybody in court arguing against this. And usually when you have uncontested situations like that, you usually win, but not always, because the judge has still got to review it and see if it makes sense to the judge. But because it's uncontested means that the courts could schedule it sooner. Because one of the main reasons that you keep pushing schedules back is the other side goes, we're not prepared. We're not prepared. Well, there's no other side to complain here, so hopefully they can get this to happen. In the meantime, the man had asked the Supreme Court to stay his execution pending the outcome of the hearing in August. So he has a scheduled execution date of September 24th. Now, you can say, Steve, we all know he's getting out. You hope he's getting out if he's innocent, but we don't know that for certain, and you never know. And what happens if the judge hears a raft of good evidence, and to everybody in the courtroom, the man appears innocent? And the judge goes, I'm not buying it. I'm tough on crime. So judges ruled they do not have the procedural authority to withdraw the execution order at this time. So apparently the rule or the law that got passed and the rules thereunder address how you can do this. There is not one. This is, by the way, if the person is scheduled for execution, the judges can stay the execution until such time as they have a hearing. Either that was an oversight or they thought, well, gee, we put that rule in there, people are going to start filing motions. But it seems to me if the prosecution brings the motion, you'd have to assume it's in good faith. But the man's attorney in a statement said she's confident that any court, when presented with all the evidence, will come to the same conclusion as the St. Louis County prosecutor that Marcellus Williams is innocent and his conviction must be overturned. And apparently she cites also the DNA evidence as being compelling. There is still time to right this wrong. No one wants to see Missouri execute an innocent man. And by the way, I will admit that when I was younger, I used to be pro-death penalty. I thought, boy, people commit heinous crimes, no problem. That's what we should do to them. And it was only when I started studying this and became a lawyer and studied it even more closely that you'll discover there are examples where we put to death people who are innocent. There are. And Timothy Masters, the guy I mentioned a few minutes ago, spent 10 years in prison for murder he did not commit. Now, he had a life sentence. But the point is that there are innocent people convicted of heinous crimes who are innocent. And if everything was done properly and by the books and so on, they wouldn't be sitting in jail for the rest of their lives or on death row. But mistakes are made. The system is comprised of humans who make mistakes, who are often fired up by prejudices or I'm not talking about racial prejudices, just you show pictures of a bloody crime scene to a jury and go, this person did it. And they might not have done it, but it's hard to not want to take revenge on somebody when you see those pictures. So, meanwhile, the prosecutor said his office is focused on the upcoming innocence hearing. While, of course, we would prefer this motion before the Missouri Supreme Court had prevailed and there were no longer an execution date looming for Marcellus Williams, our focus is on the motion we filed before the 21st Judicial Circuit and the effort to have our concerns about the conviction heard in court. A spokesperson for the Missouri Attorney General's office did not immediately respond to a request for comment from the Associated Press on Friday. So the Missouri Supreme Court was hearing this particular motion, presumably because the man and the people on his side had brought a motion saying, can we stay the execution date? And a lower court said, no, we can't. Appeals court, now the state Supreme Court says you can't because there's not a rule that allows us to do that. And that's the other strange thing. We often hear about cases where courts enter injunctions, for instance, and will stop something and just say, yeah, we'll enter an injunction to stop that because of how wrong it is. But here they're saying, well, right or wrong, there are laws that address this, and we're bound by those. So it's good that the timing is correct, that the execution is after the hearing date, but if they couldn't have gotten a hearing date sooner, the man might have a problem. And then what would happen? Because then you'd have to start running around and either get a new law passed or possibly get the governor to intercede if the governor can intercede. But it's tough. And so this is a really strange case. And you're starting to hear about people who've been locked up for years and decades who finally get the DNA tested from their evidence that's still been saved. And it turns out, and I've seen a couple where it wasn't even close. Where it was, in other words, they had two suspects and they wound up arresting this guy and convicting him. And then the DNA comes back and it was actually this guy, not that guy. That kind of thing. And so remember that juries only hear the evidence put before them. At least they're supposed to. And so if the prosecution only presents them with everything that's on one side and there was no DNA back then, well, you can't blame the jury if there's enough evidence to make it look like the person did it beyond a reasonable doubt. But of course, if the DNA evidence had been there, properly interpreted and said, this is not the guy, presumably he wouldn't have been convicted. It's just the technology wasn't there. So we're at a weird point in our society with technology. I'm sure you've heard about people now who've been caught because they left DNA at a crime scene, and they've gone to those databases where people turn in their DNA and said, oh, we know who this person is now because it turns out they're the third cousin twice removed of this person who put their DNA in the database, and we can go through and figure this out now. Here it is that a guy is sitting on death row. He's got an execution date, and they've said, we cannot delay it or adjourn it. That's just the way things are. But meanwhile, he's got a hearing where the prosecutor is arguing that the man is innocent and shouldn't be in jail. And the courts have said, yeah, that's good. Have a hearing, because that's the best we can do. So, Sean, thanks for sending it from the Associated Press. Missouri execution plans move forward despite prosecutor trying to overturn murder conviction. Questions or comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. Canada, come for the culture and scenery. Stay because your car won't start.